Who owns a car? Still owns a car? Actually, when sitting in the car, I'm not sure whether you're aware that the car actually collects a massive amount of data. There are sensors everywhere in the car. Your GPS system, there is software in the car actually gathering this data. And there is a huge fight over who owns this data. Mercedes-Benz says it's our car, we manufactured the car, it's our data. The people who manufactured the sensors, they say, no, we actually manufactured the sensors which collect all these data. The data should belong to us. They're the people who develop the software, for example, navigation software, or other control software. Say, well, listen, this is processed through our software. We should own the data. And frankly, it is our cars. So shouldn't we as car owners be the owner of the data? So I'd like to talk about two aspects today. Who owns the data? And how can we protect our business model involving artificial intelligence? So how can we go after copycats and free riders? Who owns the data? Well, data is just usually a huge chunk of information. In itself, it is not valuable until it has been analyzed. Think about a phone book, for example. The older people might remember this little yellow thing where you could look up phone numbers of people. If we just had the names of people and the telephone numbers scrambled all over as a heap of data, this would be of completely no value at all. It just becomes value because it has been structured. So there is, interestingly, data as such is not protected by law. But there is something which is protected, because once you separated and structured data in a certain way, it can be protected. There is a European directive on database law which protects the investment of a company in the structuring data and in creating this database. Because obviously somebody had to sit down and to type all those and collect all those, it's not me, collect all this data and structure it in a way that it's usable and you could sort of look up people. So the answer is basically the people who created this database, you cannot take data from them because there might be an intellectual property right involved in the structure of this data. And it has, obviously, have to be principles which have been applied to in order to make it from this to that. So who owns non-structured data? Is there an ownership in non-structured data? There are certain approaches. There is the approach that the person who owns the data medium is the owner of the data. Well, this is not really convincing because then Amazon would probably own everything with Amazon Web Services or Azure. So that cannot be really the solution to the problem. The second option would be that the person who actually inscribes the data on the medium would be owner of the data. Like the scripture of the data would be a relevant aspect. However, this is not the case either. So there is a good news for people who would want to structure business models around open data, which is either open in databases or which is just not structured at all, to take this data and to structure it yourself, because there is no intellectual property rights in just this data heap. However, obviously there are some gatekeepers, even though you have this massive amount of data which is unstructured, which you theoretically could access. People could obviously block you from this data. So on the one hand, there is no intellectual property right which prevents you from using this unstructured data. On the other hand, there is no right to access this. So people can just have their data, unstructured data, behind closed walls, and you would have no possibility to actually access this. So going back one step to the databases. Maybe we can still make use of these databases which have been structured by others. Is there a way? Yes, there is. Because you can take, you're only prohibited from taking substantial parts of a database. Now the next question would be, yeah, I see you're frowning. What would be substantial parts? This is not defined in the directive, nor in the German Copyright Act in section 87A, where all these database rights are implemented. So basically, legal cases, they evolve, they say, well, there are two kinds of taking a substantial part. One would be, you just go there and you just grab a part of about 10% or more. That would be substantial. So you go there and just empty those bins, but you can only take up to 10%. Or if you do more, this is substantial and you infringe the person's right. The other option, infringing this person's right, is taking less, but going there every day. So even if you take less, but you do it regularly, this becomes a substantial part as well. So you will have to keep under the radar, and but still be aware that you could do, like in the phone book, you can take some of these numbers and addresses, but obviously not 10% or more. This is a ballpark number. This is not something which is, which cannot be revoked, but this is case law. So the second question is, now that we talked about data, and data is the raw material, how can I protect my business model against copyrights and free riders? And one question which is most prominent is about the algorithm. So the algorithm is basically a recipe or some kind of explanation. It's a mathematical principle. There is the algorithm for tequila sunrise, for people who are interested for having this tonight. And there are obviously several options of protection of algorithm. There is copyright. No, it is not something which has been created. This is no artistic creation or somehow with some individual and creative force, although people would say, well, obviously somebody came up with it, but it does not, is not subject to copyright law because it's not a copyrighted work. And the other option would be patent law. So the question is an algorithm patentable? And what is not patentable is mathematical methods. So anything which is just a calculation is not protectable under patent law because it is not technical. The patent law protects an invention which is non-obvious, which is new, but which has a technical impact, an impact to the outside world. And Alexa finding a Bob Dylan song is a mathematical principle, and it's a way of calculating things, but there is no technical impact to the outside world. So this is not patentable. However, if you embed the algorithm in a software which then controls some kind of external machine or some kind of external technical hardware, then you might think about patent an algorithm because you can sort of patent the whole system. So you'll have to have clever lawyers who just take your algorithm and think about how you can protect it to have this system. However, if you are have just a simple software like the Alexa idea or something which just orders honey from you, like the software in your fridge, this is something. If it's just, well, maybe software in the fridge is not a good example because then you have an outside impact, maybe even on the fridge because it might change the temperature if there is more in the fridge or less in the fridge. So if we stick to the Alexa example, it may be better. So just the mere calculation will not be subject to patent law. So what can we do in order to protect our intellectual property law? Our algorithm and our software. You already know it. It's the database. It's the database created with the artificial intelligence, which is protected by the database law. Because obviously the end result is some kind of structure and some kind of end result. And this is something which you can monopolize and where other people can only take 10% from, but you can protect this by intellectual property law. So we gave you a little bit of an overview, Stefan and myself, about the contracts, the liability, the hacking, the question of who owns the data, and the question of protecting your business models. And now we're very keen on actually getting to know your ideas and questions, and we're happy to take questions. Thank you very much.
Thank you very much for those two very interesting talks. And now we have 12 minutes of Q&A, and I'm very sure that we will have a very lively discussion. Go ahead, please.
Yeah, two questions. First of all, what is structured data? So when does it start to be structured in like the eyes of the law? And then the second question, what if you take this database and you don't take 10% of every column, but you just take one column and all the data out of more than 10 columns?
Yes, those are the questions we're dealing with every day. And interestingly, what strikes me is that the case law on database rights is very slim, very narrow. There are not many cases because the economic impact is huge. So you would think that would be litigated much more, but actually it isn't. So we only have very scarce case law, and we have to sort of, when we do consulting, say, well, what can you do? Where's the gray area? Where's the white area? Where's the black area? We'll have to be very careful, and we just have some columns we can stand on. Usually, we look at the overall database as 100% of everything, unless you could basically divide the database in subgroups which are autonomous. And then it doesn't make a difference whether you took 10% like from one column or from all the columns a little bit, or just one column in full. There is no difference. It's just a question of what is substantial. And obviously this is open to interpretation, and then in the specific case, a court would decide on whether this was substantial or not.
Okay, so basically if one column is sufficient for you to make something out of it, then probably it's not.
Yes,
okay.
yeah. And the level of database protection is relatively low. I gave you the example of a phone book. This is not like a mind-boggling structure somebody invented to attribute a telephone number to a name. We have to keep in mind that the aim of this database regulation is protecting investment. So if there has been some protective investment been made in order to create this database, then it would actually enjoy protection.
So with the example with the fridge, we already came to like terms of usage and everything, but I'm wondering, is there anything in law or changing in law currently where it says, hey, you have to express it so a user understands the consequences? For example, license agreement can say, hey, this fridge will order what you want before you even know it, but it doesn't tell you it might also order stuff you don't want. So is there anything like any movement in law where we see things need to have a certain expressiveness so people can really judge the consequences of their doing?
Well, if I understand your question correctly, this is then the relationship between the seller of the fridge and the owner of the fridge. And of course, as a seller of the fridge, you have also obligations if you conclude an agreement to make the people, the purchaser, maybe aware of things. And there are always liability rules governing the relationship between these two parties. But this has nothing to do with the seller of the honey and the owner of the refrigerator. And of course, if the buyer of the fridge makes an agreement with the seller of fridge, they have their own liability rules. And if there is a malfunction or an error of fridge, then it may be that you as the owner of fridge can claim damages against the seller of fridge because it's maybe not programmed in the right way. But you as the owner of fridge, and this is the other side, will always be liable for what Frigi did in towards third parties that agree with you, to make an agreement with you. You know, this, you always have to differentiate these two relationships. Yeah, please.
Yeah, what happens if this third party that interacts with Frigi, so the vendor of the food, if that one exploits some flaw in Frigi to make it order 10,000 honey's? So if it's not an sort of outside hacker, but the hacker is actually involved.
The seller
in the
itself.
transaction,
Yes, but then from the view of Frigi, it's still an outside hacker. It's always a hacker, and this we have.
So Frigi would still be responsible.
Frigi, yeah, not Frigi, but the owner of Frigi. And we have this also when human beings interact, that if the agent works together with the seller to the detriment of the principal, to George, then they will also be liable. Then we will not have a binding agreement at all, and there will also be other claims. So the hacking example, I think, would be the same here, what you asked.
Okay, so it would be a great business model to exploit Frigi's from the seller point of view.
Yes, but no, yeah, maybe, but then you can identify, of course, the hacker. Because if you identify the hacker, then the hacker will be liable.
Okay.
Only if you don't identify him, if he's somewhere in China or whatever. Or somewhere else, sorry.
I avoided
You always have to be careful. It can also be in Russia. Maybe they don't make it worse now.
North Korea.
North Korea, that's good.
Complaint.
Or in Hamburg in my office, I don't care.
So it was mentioned that one cannot patent an algorithm. As far as I know, that is only like German or European law, and American law sees that differently. What are the actions that cause me, like if I'm a software developer and I develop an algorithm, when do I fall under German law and when does the American law apply? Is it when I sell something there or because I develop it?
Yes, intellectual property law is always connected to territory. So you will not have like a patent in all over the world, but you would have a patent in certain countries. You would apply for a German patent or a European patent or a French patent or a US patent, which makes it quite costly if you just go and patent it in most of the developed countries. So you could only enforce an American patent in America. It's not valid anywhere else. So you might have some protections scattered and some countries where you can do it freely without any restriction because there is no patent protection. And you have to patent the invention directly before you divulge it. So you cannot wait and just talk about it and then patent it because it's not new anymore. You would have to keep it secret. Maybe that's a good advice for everybody. Don't talk about it, just keep it secret. Then you apply for a patent and then you can go to a conference. There is a famous example of a professor who came up with a great idea, great invention, and he talked about this great invention at a conference. And a day later he applied for a patent, and the patent office says it's not new. And he said, why? Well, somebody talked about it one day before you applied for the patent. Said, well, that was me. So regardless, there is no protection for yourself disclosing it. So for patent law, it's very, very strict. It has to be new worldwide. So even if in Kazakhstan, in some library, you find something, this will kill your patent.
My question was a little bit in the future, and we might need to do a couple of steps before we can actually deal with this, but are there any discussions or approaches in law on how to deal with a strong artificial intelligence, so a technology that doesn't depend on big data and machine learning, but can do its own decisions on a free will?
Well, the question is probably the question of conscience of a machine, which is obviously on a philosophical level. So we're doing the groundwork. We're not up here, the philosophers. However, I think, yeah, I don't think that there is so much discussion because people think it's so far away, and we cannot really shape it. We cannot really. We just have some schematic ideas. So it's very difficult to talk about that from a legal perspective because you need more than just an outline.
And law evolves really very slowly. I mean, it's not that we make now kind of legal acts for the future. Most of the time, the German parliament or other parliaments react, but they don't act in advance. And it's most of the cases, it's case law that is confronted with the situation at the first time, the courts, and then they decide something, and then also the lawyer makers recognize, well, we need a new act on this. There are a lot of discussions, of course, with problems that we have at the moment, but as Christian said, I think there is no time or no will, or maybe it's really too far away to discuss things now that will happen in 50 years, but in 50 years we will discuss these questions, and then it may well be that Frigi has an own legal personality. Because, as I said, I think 100 years ago, nobody could imagine that a corporation can have own liability, that you as a person sign an agreement in the name of a company, and then only the company is liable, and in normal cases, never the person that signed this agreement for the company. And this, I think, the same will maybe also happen in 50 years, but who knows?
I didn't expect that they're ready to go along.
Why did you ask the question? Okay.
One last question.
Please.
Something to appreciate. Is there something based on the practice and stuff you see where you two think, oh, we probably should have a new law to handle this or this? Like, is there some new development in what your clients come up with? You think, probably we need a law for this.
I think regulation is quite sufficient at this moment in most aspects. And we should not forget that the law is also quite flexible. For example, the contract law Stefan talked about dates from 1900. So it has been changed, but there is still provisions in there, and quite a lot, from 1900. So 1900, we sold horse carriages under this regulation, or this law, civil law, bürgerliches Gesetzbuch. And today, we deal with artificial intelligence, pardon? Honeypots, yeah. So law is already quite flexible. We saw this also with rise of the internet. Obviously, there was some.
I wanted to add something.
Yeah.
Thank you very much for those very interesting talks, and I'm sure that we will have a 6-minute break, and then I'm sure that both of you are willing to answer any further questions.
You need this break now, we know that.